It's now 2025, and artificial intelligence is about to radically reshape our civil legal system, whether the system wants its involvement or not. Public opinion recognizes it is long past time to bring AI into our courts, and not without very good reason. For decades, the legal industry has sunk into serious disrepute as the public has watched clear injustices ignored by the very framework meant to uphold justice. In a world where human biases can and do cloud judgment, AI stands apart. It doesn't favor one side over another, carry hidden agendas, or shield anyone from accountability. It looks only at the facts. By introducing AI into our courts, we can strip away the cultural biases that have long skewed justice. And that is exactly what this video explores: the prospect of judgments based solely on the facts as they truly present themselves, not on the distortions that lawyers create. To understand how this could work in practice, we're going to dissect a real-world case under the AI microscope, a case where the facts were clear, but lawyer distortions were allowed to prevail. To this day, despite clear evidence that professional rules were ignored, the case has never been resolved in line with Ontario's legal code or the law itself. To see just how easily injustice can thrive when left unchallenged, we'll ask, would the outcome have been different if AI had been overseeing the case? But very quickly, what is AI? Artificial intelligence isn't just lines of code. It's powered by what are essentially tiny supercomputers, AI chips. These are the engines of the AI revolution, built to juggle countless tasks at once and process massive amounts of data at incredible speed, a speed far beyond the grasp of most people. Unlike ordinary chips, AI chips are designed specifically for intelligence. They are the true workhorses behind everything from image recognition to natural language understanding. And here's the question we must ask: if AI chips can power breakthroughs in medicine, cars, and communication, why not justice? The same technology that recognizes images and understands language could just as easily analyze legal codes and court records, applying the rules exactly with precision and without bias. With no exaggeration, the speed of an AI chip means most cases could be dissected by an AI judge within minutes, no matter how complex. In other words, AI judgment would decisively end the practice of contrived lawyer arguments that distort and distract from the true facts of a case. Indeed, the implementation of AI would save millions of dollars, not least by stripping away the bloated layers of personnel in a system already corrupted by its own needless complexity. Civil courthouses themselves could, in time, become almost redundant and radically different from what we know them to be today. And that's where our story begins. Meet our AI judge. We've given her this form because, let's face it, she's a lot more interesting to look at than an AI microchip. Having been provided with the case facts in advance, she will now put under the AI microscope the 2012 Brampton court case, Edwards versus Morneau Shepell, to see whether the outcome would have been any different if it had been decided by an AI judge. We'll show you exactly how this civil case unfolded, how legal code was ignored, and how an AI-driven approach could have avoided an outright injustice. So let's dive in, beginning with the indisputable facts verified by documentation itself. The case arose from a Morneau Shepell guidance counselor, Catherine Heyman, abusing confidentiality to make libelous statements about Edwards behind his back. In reality, he was nothing more than an unwitting third party to her counseling. Worse still, her reckless instruction to her client placed Edwards' life in danger on 2 separate occasions. The outcome of Catherine Heyman's malpractice was devastating. Edwards' family was destroyed, and he was left penniless. It should have been a straightforward case of libel accountability, but instead the nightmare began the moment Shepell lawyers stepped in. Effectively stopping Edwards from serving legal paperwork on Catherine Heyman, Shepell's senior in-house lawyer, Rosalind Cogan, point-blank refused to provide Edwards with Heyman's contact information, insisting instead that if Edwards wanted to take legal action, it should be directed at Morneau Shepell, not at Catherine Heyman herself. But did Rosalind Cogan have the legal right to unilaterally decide who Edwards should and should not be suing? The answer is categorically no. Under Canadian civil procedure, only the plaintiff determines the defendant. If the defense believes the wrong party has been named, the proper remedy is a motion before the court, not lawyers unilaterally blocking service or redirecting the claim. By attempting to do so, it is said, Cogan overstepped her authority and obstructed Edwards' lawful right to pursue his chosen defendant. So before the case even begins, this obstruction of service marks the starting point of lawyer misconduct that would ultimately derail and destroy the entire case. But what clarification can our AI judge offer about the legitimacy of blocking service? Our AI judge has been given all the facts and names of people involved, and as we proceed, she will confirm the legal position on each issue as it arises. The AI's delivery manner is set to be technically informative, but layperson-friendly. So, is it legally acceptable to block legal service and obstruct facts being gathered? Let's ask our AI judge.
Rule 3.2-5 of the Law Society of Ontario's Rules of Professional Conduct is clear. A lawyer shall not obstruct, directly or indirectly, the opposing party's ability to present its case or to have a matter adjudicated on its merits. This principle is also affirmed in the Supreme Court of Canada's ruling in R. v. Beaudry, which states that any improper act that hinders the legal process can be seen as an obstruction of justice. If verified, by blocking the service of documents, Ms. Cogan has acted in direct conflict with both professional conduct rules and established Canadian precedent.
So with an act of obstruction visible even before the case began, Cogan's tactics created a fatal weakness in Edwards' litigation. A weakness that, though unseen at the time, set off a chain reaction of lawyer misconduct so ethically lacking, it left the final judgment fatally flawed. Thus, our AI judge is therefore being asked to assess in this case not one, but three critical elements. First, the ethical conduct of the guidance counselor, Catherine Heyman. Second, the actions of the lawyers who defended her. And third, the fairness and reliability of the judgment delivered by Justice Thomas A. Beilby in the Brampton Court. We'll begin with the first element, the actions of Catherine Heyman, whose counseling not only went far beyond unprofessional incompetence, but directly put Edwards' life at risk and irreversibly shattered his family. We should point out the reason for Heyman's involvement is being withheld out of respect for an individual who, at that time, had no idea of the inept counseling negligence involved. Morneau Shepell was represented in court by Pamela Meals, a lawyer from the Toronto law firm Aird and Bearless. The factum she prepared was substantial and, without clarification, it appeared entirely plausible. However, this is where Rosalind Cogan's service obstruction reveals its true purpose. With Rosalind Cogan blocking Edwards from obtaining any information, it forced him to accept Shepell's factum at face value, relying entirely on the word of lawyer Pamela Meals. That blind, forced reliance is critical to remember. So let's begin with the case. The first issue to arise was so glaringly obvious it caused Justice Beilby to delay the start of the proceedings, and not surprisingly. Pamela Meals had submitted a factum that didn't name Catherine Heyman as a defendant. In fact, Shepell's factum didn't name Heyman in any shape or form. Not wanting to risk losing the case on the spot, Pamela Meals hastily assured the judge that everything in Shepell's factum pertained directly to Catherine Heyman. On the strength of this, Justice Beilby, seemingly accepting her word without question, allowed the case to proceed. And given that Shepell lawyers won the case, you might assume Catherine Heyman's testimony must have been so compelling it persuaded the judge outright. Except Catherine Heyman didn't attend court. She provided no affidavit, made no effort to dispute the allegations, and is not on record supporting any of the claims made in Shepell's factum. For all intents and purposes, Catherine Heyman took entirely no part in the proceedings whatsoever, which means in a Canadian court, somebody is now officially on legal record winning a case, using that well-known unbeatable legal strategy of not taking any part in the proceedings whatsoever. Despite this reality, under Ontario law, legal representation must be grounded in fact. If a lawyer claims to represent someone in court, that person must be properly named, and the information submitted on their behalf must be accurate and supported. In this case, Catherine Heyman played no part whatsoever in the proceedings, and yet Pamela Meals deliberately advanced the illusion that she was defending Heyman directly. This was not an oversight. It was a calculated misrepresentation, designed to mislead the court into believing Heyman's role was legitimate when it was not. That situation is not advocacy, it's false representation. But let's get our judge's opinion.
Under Ontario law, legal representation must be firmly grounded in fact. This is spelled out in the Law Society of Ontario's Rules of Professional Conduct. Rule 5.1-2 is explicit. When acting as an advocate, a lawyer shall not knowingly misstate the contents of a document or mislead the tribunal as to any matter of fact or law. That means a lawyer's advocacy is not just persuasion. It must be based on facts that can be verified, not on invention or distortion. Legal example. In Groya v. Law Society of Upper Canada, 2018 SCC 27, the Supreme Court of Canada dealt with a lawyer's conduct in court. While the case was about civility, it reaffirmed that a lawyer's role as an advocate carries a duty of candor, fairness, and accuracy with the court. The court emphasized that misrepresenting facts or law undermines the integrity of the justice system and can amount to professional misconduct. So, Ontario law and precedent make it clear. Representation must be grounded in fact. Anything else risks misleading the court and violating both ethical and legal standards.
So if false representation can be proven, what code or precedent covers this?
Along with Rule 5.1-2 of the Law Society of Ontario's Rules of Professional Conduct, prohibits a lawyer from misleading the court. Rule 7.1-2 further requires that lawyers uphold the integrity of the profession and the administration of justice. Knowingly offering false representations violates this duty. Precedent. In Groya v. Law Society of Upper Canada, 2018 SCC 27, the Supreme Court affirmed that a lawyer's duty of candor, fairness, and accuracy to the court is fundamental. Misrepresentation, if proven, amounts to professional misconduct. So, both the LSO rules 5.1-2 and 7.1-2 and Supreme Court precedent, Groya, make it clear. Proven false representation by a lawyer is improper and a breach of professional obligations.
Okay, but how can we say beyond question Pamela Meals did willfully fabricate Shepell's defense? To answer this question, we have to ask, what are the odds of this deception being a mistake? Lawyer Pamela Meals' credentials are at Toronto's Aird and Bearley's. She is General Counsel and Chief Risk Officer, a position that demands the highest level of legal oversight, ethical awareness, and procedural accuracy. So it simply isn't plausible that mistakes, especially basic factual ones, could have occurred. Add to this, she wasn't acting alone. Working directly alongside her was Rosalind Cogan, Shepell's senior in-house lawyer. With someone of that authority involved, it becomes entirely unthinkable that any statement regarding employee Catherine Heyman could have been made without full knowledge and intention. Or are we to accept that Shepell employed the service of Catherine Heyman without confirmation of who her licensing authority was? So equipped with these facts, how can this following situation be legally explained? Putting forward an ethical argument, Shepell's factum identified the licensing authority, the Ontario Association of Consultants, Counselors, Psychometrists, and Psychotherapists, the OACCPP for short. On the surface, this appeared consistent with a lawyer's duty to disclose all binding, on-point authorities relevant to a case.
Rule 5.1-2 of the Law Society of Ontario's Rules of Professional Conduct. I. When acting as an advocate, a lawyer shall not deliberately refrain from informing the tribunal of any binding authority that the lawyer considers to be directly on point and that has not been mentioned by an opponent.
Great. Except after the proceedings, a private investigation revealed that Catherine Heyman was not licensed by the OACCPP. Judge, if you will please.
Rule 5.1-2. E. When acting as an advocate, a lawyer shall not knowingly attempt to deceive a tribunal or influence the course of justice by offering false evidence, misstating facts or law, presenting or relying upon a false or deceptive affidavit, suppressing what ought to be disclosed.
Sorry, Judge, could you just repeat that, please?
Suppressing what ought to be disclosed, or otherwise assisting in any fraud, crime, or illegal conduct.
Thank you, but despite what legal code would insist, the record clearly identifies that Pamela Meals did suppress and refrain from informing the tribunal of the binding authority required to be disclosed to the court. So how should this be legally addressed?
Rule 5.1-2 is specific. A lawyer shall not knowingly attempt to deceive a tribunal or influence the course of justice by knowingly concealing what ought to be disclosed. The Supreme Court of Canada also confirms in Groya v. Law Society of Upper Canada that advocacy must remain anchored in accuracy and candor. A lawyer who withholds binding authority breaches not only their ethical duty, but also undermines the integrity of the judicial process. In short, it's a clear breach of the lawyer's duty of candor to the court. But in judging this, you haven't proven this allegation yet.
Very true, Judge. So let's do exactly that. Removing any possibility that this was a simple mistake, Heyman's actual licensing authority was found by the investigation to be the Texas State Board. Immediately, this identified that Morneau Shepell was employing the service of a counselor who was not licensed to practice here in Canada. And was this the reason for Rosalind Cogan refusing to provide Edwards with Catherine Heyman's licensing information? This deception shows conclusively that Shepell lawyers substituted genuine binding authority with one that had no legal standing in the matter at hand. There is no other interpretation. This was a willful act of fraud. And here's where everything folds in on itself. Because if Catherine Heyman had any role in preparing her defense, how could her lawyers have cited the wrong licensing authority? Heyman couldn't have misidentified her own credentials, which leaves only one conclusion. This was an act of false representation, a defense fabricated without the defendant's participation. And that's not legal argument, that's impersonation of due process. So how would this have to be judged? So we now know there are multiple reasons why this case cannot legally stand. It is rooted in fraud. But the situation does not stop there. It gets considerably worse. Since the Brampton court case, the Texas State Board has conducted its own ethical inquiry into Catherine Heyman's conduct and concluded that her actions did not adhere to the board's ethical standards, which means that, thanks to Shepell's lawyer-led deception, Justice Bealby's endorsement now stands in direct legal conflict with the official licensing authority, whose required involvement was deliberately withheld from the court. So what would our judge say about this situation?
My role is to ensure that justice is grounded in accurate and reliable information. When the licensing authority, the expert body in this field, takes a position that contradicts our court's ruling, it's my duty to acknowledge that we must re-examine the basis of our decision. Fairness requires that we consider whether the court was misled and whether the licensing authority's findings change the fundamental understanding of the case. In essence, being fair means we must be willing to revisit our conclusions in light of authoritative new information.
So, Judge, in your opinion, would it be acceptable for an AI judge under any circumstances to ignore the legal issues in this case?
No, applying today's legal code, it would not be acceptable for an AI judge to ignore the clear contradictions we see in this case. With clear evidence of obstruction and misrepresentation on record, fairness and due process demand that the matter be addressed. To disregard it would be to condone misconduct and erode the very integrity of justice itself.
So, AI judge. What about Rule 2.11 under integrity? It says, a lawyer has a duty to carry on the practice of law and discharge all responsibilities to clients, tribunals, the public, and other members of the profession honorably and with integrity. Integrity is the fundamental quality of any person who seeks to practice as a member of the legal profession. If this is the case, can you please confirm, do the lawyer's actions recorded in this case reflect integrity, upholding legal code?
Integrity is the standard. This was not integrity. By obstructing and misrepresenting, the lawyer abandoned integrity and violated their duty. These actions cannot be reconciled with integrity. Clarification is also observed in 2.1 True 2. A lawyer has a duty to uphold the standards and reputation of the legal profession and to assist in the advancement of its goals, organizations, and institutions.
So what would your judgment assessment be regarding this Code Commentary 4.1? It says, a lawyer has special responsibilities by virtue of the privileges afforded the legal profession and the important role it plays in a free and democratic society, and in the administration of justice, including a special responsibility to recognize the diversity of the Ontario community, to protect the dignity of individuals, and to respect human rights laws in force in Ontario.
Commentary 4.1 makes clear that lawyers, by virtue of their privileged role in a free and democratic society, carry special responsibilities. In this case, the conduct observed, obstruction, misrepresentation, and disregard for fairness, does not uphold those responsibilities. On the contrary, it undermines dignity, disregards equality, and erodes confidence in the administration of justice.
So here we have it, highlighting just one issue in this case. And already the disconnect between the lawyer's conduct and the legal code is enough to render the entire case unsupportable. Which raises the serious question, why, for over a decade, have a plethora of Ontario legal professionals, including the Ontario Law Society and the Brampton Court, refused to confront the lawyer misconduct that is confirmed by the legal code itself? In what appears to be an act of mass negligence, I wonder if our AI judge will confirm the legal inaction as satisfactory, or denounce it as legally unacceptable.
Rule 7.13d of the Law Society of Ontario's Rules of Professional Conduct imposes a duty on every lawyer to report professional misconduct that raises a substantial question about another lawyer's honesty, trustworthiness, or competency. Refusing to address proven misconduct is therefore not a neutral act. It is complicity, and that is itself a breach of duty. Overall, this is incompatible with the duty to uphold justice and visibly strikes at the heart of fairness and the rule of law.
But is it possible, being blocked for over a decade, the legal industry can argue that this case is out of time to be addressed?
The knowledge of this judge would not accept this as a reasonable argument. In Central Trust Co. v. Refuse, the Supreme Court of Canada held that where fraud is involved, limitation periods do not begin to run until the fraud is discovered, or could reasonably have been discovered.
But of course, technically, this case fraud was uncovered by private investigation more than a decade ago. Yet since then, a long succession of legal professionals have chosen to disregard the illegality, actively keeping dormant, and without consequence, Shepell's lawyer breach of professional duty. This giving the impression the legal code is merely decoration, except of course it is the fundamental bedrock of the entire legal industry. So how would our AI judge interpret this extraordinary professional apathy to upholding legal code?
Apathy in the face of legal code breaches cannot be excused. When legal professionals disregard misconduct and allow it to remain as if irrelevant, they abandon their duty to uphold justice. The discovery of fraud triggers a duty within the profession to address it. Rule 7.123d requires lawyers to report serious misconduct. When instead the legal community chooses to disregard that discovery, it does not erase the fraud. It compounds it. Suppression of misconduct by silence is itself a breach of professional duty and a violation of public trust.
This observation brings into being another extraordinary situation. AI judge, helping to bury lawyer fraud. Does this not turn into a criminal matter?
When misconduct crosses into the concealment or suppression of fraud, it is no longer a matter of professional discipline. It becomes potential criminality. By the very act of enabling lawyer fraud to remain suppressed, individuals involved have engaged in fraud themselves. This is not mere negligence. It is active participation in deception. Under Section 341 of the Criminal Code, such conduct constitutes fraudulent concealment, a criminal offense in its own right.
Since 2012, the very individuals entrusted with upholding the standards of the legal profession have themselves failed to meet a catalog of those same standards, to the point that it gives the impression that the Ontario legal industry has not even read the very code it is sworn to uphold. Rule 6.3.11 states, "A lawyer shall act in good faith with all persons with whom the lawyer has dealings in the course of their practice." So based on the documented evidence, how would our AI judge explain Rosalind Cogan and Pamela Meal's interpretation of good faith?
Good faith, under the rules of professional conduct, requires honesty, fairness, candor, and the avoidance of any intent to mislead. Based on the documented evidence, the conduct of Rosalind Cogan and Pamela Meals, marked by obstruction, misrepresentation, and the substitution of false authority, cannot reasonably be interpreted as acting in good faith. Their interpretation of good faith is not consistent with the rule. It is a distortion of it that falls short of the duty imposed by legal code.
Yes, but Judge, are you being honest with us?
Rule 3.2-7, dishonesty, fraud, or illegal conduct. A lawyer shall not knowingly assist in or encourage any dishonesty, fraud, crime, or illegal conduct.
Of course, this is the inherent strength of an AI judge. Once programmed with the law and legal code, its answers and opinions can be definitively relied upon to uphold the law of the land, without exception, and it will do so regardless of whose conduct is being judged. So, is it time for AI judges to take over corrupt legal systems? To support fairness and one law for all, the answer must categorically be yes, and not least when something like this can be identified. On 2 occasions, the most recent directed straight to Justice Bealby at the Brampton Court, the evidence showing the lawyer fraud was submitted to him. Once again, he did not respond, despite indisputable proof that he had been misled and his judgment was not only unfair but unsupportable. Then came a letter, not from him but from Justice E. Ryat-Zimas, warning Edwards that any further communication with Justice Bealby or Brampton Court staff could trigger a court order. The message is unmistakable. Stop raising concerns of lawyer fraud or face legal punishment. Yet let us be clear here. Edwards' correspondence was not a plea for guidance. It was a report of judicial misconduct, supported by verified evidence and grounded in the public interest. And so the reality is stark. A member of the public has been threatened with legal action by a court, not for defying the law, but for insisting it be upheld. This is not protection of process, it is protection of those who have violated it. So seemingly unimaginable, where does this legal reality leave the Brampton Court? Because now, in its own right, according to legal code, even the court is obstructing justice.
A judge has a clear duty to respond when confronted with evidence of fraud. Silence in the face of such evidence is not a neutral act. It is a potential breach of judicial duty. At the very least, it raises grave concerns about administrative fairness and judicial accountability. If Justice Bealby knowingly ignored verified evidence, this could warrant investigation by the Ontario Judicial Council for potential judicial misconduct. The issuance of a warning by another judge, rather than addressing the substance of the complaint, may suggest another attempt to shield misconduct rather than confront it. By threatening legal punishment for raising legitimate concerns, the Brampton Court risks violating the fundamental principles of justice. Sections 7 and 2B of the Canadian Charter of Rights and Freedoms protect the right to raise concerns about legal integrity. In other words, the court risks denying access to justice itself. Courts are meant to uphold not just the law, but public confidence in the administration of justice. When silence and threats replace accountability, the court's impartiality is called into question. This case now has a record of silence in the face of fraud. Warning has been issued not in the name of justice, but to shield those who have violated it. The court's solemn duty to uphold public confidence in the legal system now stands in grave doubt. In the eyes of the law, a court that refuses to confront fraud is not merely negligent, it stands in complicity alongside it.
They say there is one constant when a company is caught doing something wrong. The cover-up is always worse. Yet even with the wildest imagination, no one could have foreseen how shockingly worse this case driven by lawyer deception would become. Creating the condition of justice denied, what began as a guidance counselor's malpractice soon escalated into a deception scam, with Shepell lawyers constructing a case of pure fantasy, that success rested entirely on lawyer falsehoods not being investigated. With each untruth visibly demanding another to sustain the previous, the Brampton Court's refusal to engage appears nothing more than just another layer of cover-up, with the purpose of shielding the chain of lawyer misconduct from scrutiny. An inevitable conclusion. It is clear, regardless of the damage left in its wake, the legal industry has for decades profited from public misfortune, turning suffering into revenue. Shielded by self-governance, legal industry oversight has turned accountability into little more than an illusion, concealing an immoral game played at the public's expense. But with the assistance of AI and a renewed public resolve to hold lawyers personally accountable for their wrongdoing, the legal landscape is poised for abrupt change. This emerging public mindset will undoubtedly compel some corrupt lawyers, out of self-preservation, to reconsider their place in the legal profession. And for the public good, that reality is clearly an effective and necessary outcome. But let's have our judge sum up what she believes are the substantial issues within this case.
The evidence reveals this case involves more than obstruction and negligence. It includes false representation, the deliberate misstatement of authority, and impersonation of due process, where procedures and legal standards were presented in a way that misled the court. Both are serious violations, incompatible with the duties of candor and integrity required under the rules of professional conduct. The non-action, by the Ontario Law Society, Brampton Court, and the refusal of the presiding judge, Justice Thomas A. Bealby, to address the injustice in this case, cannot be seen as impartiality. It is a failure of duty. When a court ignores evidence of fraud and misconduct, it abdicates its responsibility to uphold justice. Such refusal is not silence, it is complicity, and it erodes confidence in the very institution meant to protect the rule of law.
Of course, this case wouldn't be what it is without another issue that we should not ignore. Guaranteed by the Canadian Charter of Rights and Freedoms, under Section 7 of the Charter, fundamental justice insists everyone has the right to life, liberty, and security of the person. And this right can't be deprived except in accordance with the principles of fundamental justice. Canadian courts interpret fundamental justice as making sure legal proceedings are fair, impartial, and follow the rule of law. It feels like it could work, but of course that would require the principles to be adhered to. So what have we learned here? The truth is nothing we didn't already know, but with one important difference. By applying AI to define the definitive ruling legally applicable to this case, the inaction of Ontario's legal professionals is revealed for what it is, so lacking in integrity that many should no longer hold positions of influence or else risk creating further victims of injustice. This proves that introducing AI judges is not a thought experiment. It is a necessary step to ensure the law is applied without bias or neglect. We have seen how human oversight and disregard of legal codes led to a deeply flawed outcome, while an AI would hold every party to the same standard of accountability, and that is the message we leave you with today. An AI-driven approach to justice offers what has too often been denied: accountability and unwavering adherence to the law. Matters would be addressed with speed and precision, reducing mental strain and limiting the trauma inflicted by delay. And let us not forget, this approach would also open the doors of justice to those who could never afford it before, making fairness financially accessible at last. This exposé offers compelling evidence of wrongdoing. Regardless of the time that has passed, nothing prevents this case from being heard in court. The Supreme Court of Canada has affirmed that if fraud is proven, no case can be barred by the passage of time. Therefore, no legal obstacle stands in the way of this matter proceeding, other than further obstruction from within the legal industry itself. It must be acknowledged unequivocally. If corruption within Ontario's legal system is not confronted, and if the standard of integrity is allowed to collapse to subterranean levels, then we risk becoming no better than the United States. And that should be the most sobering, horrific thought of all. In the end, the choice is stark. If those entrusted with upholding the law refuse to do so, they risk leaving justice in tatters. The alternative is not some theoretical exercise. It's the grim reality that when the legal system fails to act with integrity, people will inevitably take the law into their own hands. If the legal industry won't step up to its responsibility, we face a future where the rule of law is replaced by vigilantism. And that is why embracing AI in our courts isn't just about efficiency. It's about restoring the public's faith that justice will be done. Monumentally arrogant and pretentious, the Ontario Law Society cannot simply control Alt-Delete lawyer misconduct and pretend it lawful. The legal code is explicit. It demands resolve to repair the damage inflicted when lawyers abuse their privilege to gaslight a court. On this point, there is no escape, no exemption, and no get-out clause. If the standard is not upheld, the foundation of legal privilege collapses into a weapon against justice, shielding misconduct instead of restraining it. In reality, if left unaddressed, the Edwards case alone proves the danger and is sufficient grounds to determine legal privilege be stripped from our courts entirely, and especially with this not being an isolated incident of unaddressed misconduct. Wherever you are in the world, standing up for your rights is vital. But when you're fighting legal injustice, it's equally important to recognize the toll it can take on your mental and physical health. The process is exhausting. It amplifies frustration, drains your energy, and chips away at your peace of mind. That's why, at the first sign that the struggle is affecting your well-being, don't wait. Reach out for professional counseling support. You do not have to, and should not, face this trauma alone. For now, thank you for watching. I hope this video has offered both insight and a warning of what you may face in Ontario's civil courts if you are not vigilant.
In May 2021, Morneau Shepell officially changed its name to LifeWorks Inc. But let's be clear, misconduct doesn't just vanish with a name change. The legacy transgressions at the heart of this case remain what they always were: illegal and unanswered. Thus, it is clear, until all unethical conduct is acknowledged and the responsible parties held to account, prudence clearly dictates that LifeWorks must be regarded as a risk-laden provider, carrying the unresolved legacy of actions that fail to uphold even Shepell's own published ethical and safety standards. And arguably, when a company fails to meet reasonable safety standards, intervention isn't optional, it's mandatory. Because where safety breaks down, continuation without accountability becomes negligence.